Okay, so what did we start seeing yesterday? What did we start seeing yesterday, Ma?
Constitution and labor laws.
Yes, we started with the chapter Constitution and Labor Laws. And yesterday we spoke about the Constitution, why is it so fundamental, and we spoke about what are the parts of Constitution which are guiding forces of legal framework of our country. And then we talked about what is in the preamble of the Constitution. And then we saw fundamental rights, which are in part 3 of the Constitution. And we also saw there is something called as direct principles of state policy, which is going to be in part 4 of the Constitution. And after that, we saw how Constitution and how it is affecting labor laws. We saw constitutions based on the principle of socio-economic justice. So labor laws also have the main objective of socio-economic justice, that is removing inequalities of status and removing inequalities of wealth, removing discrimination and such. Accordingly, we saw certain fundamental rights which cover the protection or which cover the rights of labor. We saw Article 14, which was equality before law, and Article 16, which talks about equal opportunity in public employment. Article 19, we saw that all people have the right to form associations or union, and they also have the right to continue to be in that association. Article 21, we saw about right to life, where the word life does not only mean about simply existing or surviving. It talks about doing anything and everything that a man wants to do to keep living uh, a worthwhile life. Then you have Article 23, which talks about prohibition of trafficking and forced labor, in which we saw human trafficking, which is abolished by Constitution. And then we talked about beggar, which is unpaid work, compulsory work for which you are not paid. And then other similar forms of forced labor. And all of these are prohibited by Article 23. Article 24 specifically talks about prohibition of child labor under the age of 14 years. And especially in factories or mines and other hazardous employments. If still children are being employed, then it is the duty of the industry and the people employing them to provide them with opportunities to study, to educate themselves, to try and better their circumstances. At the same time, they'll have to be compensated fairly for the work that they're doing. And even their parents or their guardians should be employed by the same employers. All these we have seen in fundamental rights which are relating to labor. Right? Clear? What we've covered yesterday? Everybody?
Yes, ma'am.
Yes.
Yes, ma'am.
Okay, so what we are going to start with today is we are going to start with the directive principles of state policy. The difference between fundamental rights and directive principles of state policy is that fundamental rights, they are rights of every individual citizen of the country. So these rights obviously will apply to laborers also. But directive principles of state policy are, we can essentially call them as goals, or we can call them as missions given to government by the constitution. So it is the duty of the government to take all these guidelines into consideration and frame the laws, frame the legal framework in such a manner that you will be able to achieve all these goals. For example, Article 38 talks about states shall strive to promote the welfare of people. So whenever government is making any law, then the basic motive behind the law should be to promote the welfare of the people. Understood what directive principles of state policy are for?
Yes, ma'am.
Yes. So we'll be learning Article 38, 39, 41, 42, 43, and 43A. These are directive principles of state policy which are closely related to labor welfare. Okay, because we are concerned with labor welfare, so only that we are covering in our syllabus.
Okay.
Okay. Labor laws and reference to directive principles of state policy. The makers of constitution have realized that in a poor country like India, if you want to have a political democracy, then you should obviously have a economic democracy. Only then political democracy can work. So for this, what you have to do, government has to take steps to ameliorate the socio-economic condition of the public. So today we are living in an era of welfare state which seeks to promote the prosperity and well-being of the people. So to do this, the directive of principles strengthen and promote this concept by seeking to lay down some socio-economic goals which the various governments in India have to strive to achieve. So they give you some goals to achieve and the government has to take them into consideration. These principles obligate the state to take positive action in certain directions in order to promote the welfare of people and also to achieve economic democracy. Okay, but we saw when we studied about fundamental rights, we saw that courts strictly enforce fundamental rights. We saw various case studies in which the Supreme Court or the High Court has given various judgments enforcing the importance of fundamental rights. Yes, but the difference between fundamental rights and directive principles is that the courts will not enforce directive principle on the government. Why not? It is because the state has to operate under various stresses, various obligations, various restraints. Right? So the government's job is not only about making the life of people easier, it has to do so much more than that. So you can give this as a suggestion to the government, ask them to take this into consideration, ask them to try and implement it. But if they are unable to do it in the time being, the court will not force the government to do so. Not unlike your, not like your fundamental rights. Fundamental rights, if it is not given to any citizen, at that point of time itself, the court will make a statement against it. It will give a ruling for the people in a favor of giving them their fundamental rights. But in case of a directive principle, it is only a direction. It is only a what can we say? A guideline given to the state. It is their duty to follow it, of course, because it is given in the constitution. It is their duty to follow it. They will try to do so. But if they are unable to implement it for the time being, the court will not try to enforce it on the government. Understood the difference? Are you guys there?
Yes, ma'am.
Okay. Nevertheless, the Constitution declares that directive principles, though not enforceable by any court, are fundamental in the governance of the country, and the state has been placed under an obligation to apply them in making laws. And it you can see that the courts in the judgments made for the fundamental rights, they have read into the directive principles along with the fundamental rights. So the approach now is that you have to read them both together to interpret it properly. It has now become a judicial strategy to read fundamental rights along with directive principles with a view as the latter defines the scope and ambit of the former. So fundamental rights oda scope என்ன fundamental rights oda ambit என்னன்னு புரிஞ்சுக்கணும் அப்படின்னா you need to read the directive principles is what the judicial approach is all about. So in the directive principles, there are many things given to the government as a suggestion. But what are we going to see in directive principles is that we are going to see Article 38, 39, 41, 42, and 43 because they have a special relevance in the field of industrial legislation and adjudication. So you can call these articles as the Magna Carta of industrial jurisprudence. Magna Carta means the main charter, the main rule behind industrial jurisprudence, industrial laws. Okay. So they encompass the responsibility of government, both central and state, towards the labor to secure for them social order, living wages, keeping with the economic and political conditions of the country. All right, so we will start with your Article 38, social order based on socio-economic justice. So this is the main principle behind which our whole country is framed. Okay, socio-economic justice is what is given as one of the prime mottos in our preamble itself. It is again reinforced in Article 38. So all the laws, including labor laws, have this as their background: socio-economic justice. Article 38, Clause 1 directs the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall be there. So when I talk about justice, it talks about three types of justice: social justice, economic justice, as well as political justice to all national life. So whoever is there living in our country, they are entitled to justice, social, economic, and political. Article 38, Clause 2 directs the state to strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals but also amongst the group of people who are residing in different areas or they are engaged in different occasions. So, it doesn't matter where they're living, what they do, all people should be equal. Any inequality in status or in terms of facilities and opportunities provided to them should be eliminated. So this is also one of the major objectives of government. So to fully understand Article 38, you'll have to read it along with Article 14. What is Article 14? Yes, we just saw a summary of yesterday's class. Article 14.
Equality before law.
Yes, equality before law. So to give you socio-economic justice, you have to treat people equally, right? So Article 14 and Article 38 goes hand in hand. You have to read them together to get the full meaning. This directive reaffirms what has been declared in the preamble of the Constitution also, that is the function of the Republic is to secure social, economic, and political justice, right? So on this concept, envisaged by the Article 38, you have a Supreme Court case, Sri Srinivasa Theatre versus Government of Tamil Nadu. Here, the ruling goes like this: equality before law is a dynamic concept. What is the meaning of the word dynamic?
In a large variety, in a,
Dynamic is ever
not a
changing.
not a narrow way.
Yes, it is always changing. Equality before law is a changing concept. In different circumstances, it has different facets. Okay, so it has many facets. One facet that is most commonly acknowledged is that there shall be no privileged person or class before law. Okay, before law, everybody is equal. You may be anybody, you may have any amount of money, you may be from any big family, but before law, nothing matters. That is one facet when we talk about equality before law. At the same time, we also talk about equal protection under law. So equal protection under law is not possible when there are inequalities between people. Yes, by status, by their economic resources, people are unequal. So when there are so many inequalities among the people of India, you cannot treat all of them equally when I say equality before law. So first of all, to apply equality before law, you'll have to give some special advantages, make some special provisions for people so that inequality can be reduced. After that, you can apply the principle of equality before law. That is why we have provisions for reservations and such. Understood?
Yes, ma'am.
Yes, so for equality before law can be predicated meaningfully only in an equal society. So to make the society equal, you'll have to try to reduce inequality. That is why you have Article 15, which talks about equal opportunity. Okay, so when you provide equal opportunities, only then people can be on the same standing. And if there are people of the same standing, then you can apply the same rule to them. Otherwise, you will be making or creating an injustice by putting people from different standings towards the same, what can I say, strata. Next thing, reading Articles 21, 38, 42, 43, 46, and 48A together, Supreme Court has concluded following in the Consumer Education and Research Center versus Union of India. Right to health, medical aid to protect health and vigor of a worker while in service, also post-retirement, is a fundamental right. So this is also one of the landmark rulings given by Supreme Court, which says that right to health and right to medical aid to protect the health and vigor of a worker, whether he's in employment or even after retirement, is a fundamental right. This is because health of a worker enables him to enjoy the fruit of his labor, keeping him physically fit and mentally alert for leading a successful life economically, socially, and culturally. So, medical facilities to protect the health of workers are therefore the fundamental and human right of the workman. Understood? It's a very important ruling. Workmen, whether they are still in service or not, even after retirement, they have a right to medical aid and they have a right to health. As you have to read Article 38 with Article 14, Article 38 is also supplemented by Article 39. Okay, Article 39 lays down the guidelines and principles for achieving socio-economic justice. Okay, so Article 39 talks about equal pay for equal work. So till now, yesterday also we started talking about equal pay for equal work, and what we have learned till now about that is you have to pay equally for equal work done. When I say equal pay for equal work, we talk about same amount of qualifications a person should have, same amount of roles, duties, and responsibilities should be carried by them. Despite doing that, if there is a difference in pay, then you can fight for equal pay for equal work. Okay, but equal pay for equal work does not mean that there can't be any difference in pay scale. For example, a doctor will be paid more than a nurse. Yes.
Yes.
A professor will be paid more than a teacher. Why? Because they have different qualifications, they have different experience, they have different duties, and they have different responsibilities. So if these things are different, you cannot ask for equal pay. Clear? So ஒரு ப்ரொஃபஸருக்கும் இன்னொரு ப்ரொஃபஸருக்கும் சேம் அமௌண்ட் ஆஃப் ரோல்ஸ் அண்ட் ரெஸ்பான்சிபிலிட்டிஸ் இருக்கு, சேம் எஜுகேஷனல் குவாலிஃபிகேஷன் இருக்கு, ஸ்டில் பேமெண்ட் மாறுது அப்படின்னா தென் இட் இஸ் தேர் ரைட் டு ஆஸ்க் ஃபார் ஈக்குவல் பே. பட் ரெஸ்பான்சிபிலிட்டிஸே வேற, உங்க ஜாப் டைட்டில்ஸே வேற அப்படின்னா தென் யூ கேனாட் ஆஸ்க் ஃபார் ஈக்குவல் பே. திஸ் வாட் வி ஹவ் சீன் டில் நவ். Okay, so we'll see what is given in the Article 39 about equal pay for equal work. So Article 39 requires the state in particular to direct its policy towards securing all citizens, irrespective of sex, equally have the right to adequate means of livelihood. So basically, equal pay for equal work, எதனால major problem ஆகுதுன்னா, usually it is because of gender inequality. Men doing the same work and women doing the same work, still they'll not be getting the same pay. Women will be paid less. This is a major inequality in income. Right? So that should be avoided. So the first point itself, they're talking about inequality in gender. So all citizens, irrespective of which sex, they'll have to be given the right to earn adequate means of livelihood, and ownership and control of material resources of the community should be distributed in such a manner that everybody is benefiting. So it should not be in the hands of a few selected group of people so that they'll be helping out only who they want to. Okay, so ownership should be spread out so that all people are benefiting from it. The operation of economic system does not result in concentration of wealth in the hands of a few people. That is also very important. And there should be equal work for both men and women. Health and strength of workers, men and women, and also tender age of children should not be abused. And citizens should not be forced by economic necessity, which means need for money, to enter into avocations unsuited to their age or strength. So we already spoke about why there is child labor, because of poverty. So just because they need money, children should not be pushed into jobs which are not suitable for their age and strength. Children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, that childhood and youth are protected against exploitation and against moral and material abandonment. So these are the principles, directive principles laid under Article 39. So what all government should take into consideration when it is making laws. For this, we have some case studies. The first case study is in the case of Ranveer Singh versus Union of India. Supreme Court has held that the principle of equal pay for equal work, though not a fundamental right, it is certainly a constitutional goal. Article 39, Clause D of the Constitution proclaims equal pay for equal work for both men and women as a directive principle of state policy. Okay, and they also clearly mention that this doctrine is equally applicable to persons employed on a daily wage basis, not only people who go to white collar jobs. Even if they are people who are earning on a daily wage basis, this principle will apply. So you can usually see that construction workers, no, they work on a daily wage basis. You know that, right?
Yes, ma'am.
They work on a daily basis, dina kuli. Yes. So usually men who work on construction basis, they earn more than women who do the same work. Yes. They say if you get one man to work on your project for one day, it is 1,000 rupees. If it is a woman coming to work, maybe she'll be paid for the same day's work 700 or 800, which is inequality in your pay. So this should be avoided, and that is what Supreme Court is saying. It is not only about white collar jobs like working in big MNCs and corporates. Even in these circumstances, like daily wage workers, equal pay for equal work for both men and women is applicable. Okay. However, as we already know, this doctrine of equal pay for equal work, you cannot put it in a straight jacket, which means if people have different roles and responsibilities, then according to what they do, the payment can differ. Yes. Okay.
Yes, ma'am.
Next thing, we come to the case of Dhirendra Chamoli and another. This is state of UP. Here, the court stated that the fact that the employees accepted employment with full knowledge that they will be paid only daily wages and they will not get the same salary and conditions of service as other class 4 employees cannot provide an escape to the central government to avoid the mandate of equality enshrined in Article 14 of the Constitution. So, if நீங்க ஒரு பர்டிகுலர் கிளாஸ் ஆஃப் எம்ப்ளாயிஸ் வச்சிருக்கீங்க, ஹியர் இட் இஸ் கிளாஸ் 4 எம்ப்ளாயிஸ், அவங்க பண்ற அளவுக்கு இன்னொரு குரூப் ஆஃப் எம்ப்ளாயிஸ் வேலை பண்றாங்க. And even though when they entered into the employment with the knowledge that they'll be paid daily wages and they'll not be given the rights of full-time employees, it doesn't matter because they are doing the same work as class 4 employees. So they should be given the same amount of remuneration and same amount of conditions which are provided to the class 4 employees. This is the judgment. Understood, ma'am? Yes. Okay.
Yes, ma'am.
Next thing, you have National Campaign Committee for Central Legislation on Construction Labor versus Union of India and others. So here the petition was filed towards non-implementation of two acts, BOCW Act and Building and Other Construction Workers Welfare Cess Act. So the Cess Act and the BOCW Act was not implemented. Either against a person has made a petition to the court. So what was the ruling? So both these acts were put in place to keep by keeping in mind the principles of directive state policy, which means they are ensured, they are used to ensure that the articles mentioned under directive state policies are working in the country. So if you are not applying them, then you are, what can we say? The purpose of the legislation itself is missed out. So you have to apply them. The rule of law must be respected. Along with it, the human rights and dignity of building and construction workers must also be respected, was the ruling given by Supreme Court. So what are the articles affected here is Article 15, Equal Opportunity, Article 39, also Articles 45 and 47. In addition to this, court also added that Article 21 also should not be forgotten because you need to give all workers, all people a life of dignity, which is their fundamental right. Next, you have Bandhua Mukti, Morsha and others versus Union of India. Here, a petitioner made a complaint saying that you should not employ children in any industry, including a hazardous industry. Okay, so child labor should be illegal is what the petition was all about. Not only hazardous industry, in all industries. Because it is violative of Article 24, Article 39 and Article 45 of the Constitution, which is read along with the preamble. So court made the following ruling. Court has considered the constitutional perspectives of abolishing child labor and the children below 14 years of age in industry. So what it came to uh, was it decided that you cannot totally abolish child labor immediately. Because why is that child labor? It is there because people need money. So if you take out the opportunity from them, the way of earning money, then it will become quite difficult for them to lead their lives. So we are going to do something called as we are going to introduce principles which is going to help in progressive elimination of employment of children below the age of 14. Okay, so not immediately or totally banning it, but step by step, slowly you're going to take back the children being employed in various industries. So how to do that? Number one, you're going to give compulsory education to all the children, either by the industries who are employing them or industries along with state government. Then you will give them, apart from education, periodical health checkup. You will give them nutritious food, and you will entrust the responsibilities for implementation of the principles. All the reports of progress made in this behalf should be submitted to the registry of the court. This was the order made. Yes, understood? No?
Yes, ma'am.
Instead of immediately banning child labor, you want to slowly roll it back. How do you do it? By bringing in different principles, different policies. What are the policies? You're going to help them educate themselves. So you give them education, free education, and you give them health checkups, you give them nutritious food, and whatever is necessary for bringing in all the policies, all that you have to do. And whatever progress is made, report about that should be submitted to the court. This was the ruling given. Okay. So next thing is Article 41. Article 41 is about social security provisions. So Article 41 requires the state within the limits of its economic capacity. So however much it can do with the amount of resources that it has to make effective provision for securing the right to work, right to education, and right to public assistance in cases of unemployment, old age, sickness, disablement, and other cases of undeserved want. So Social Security as a right is guaranteed in the Constitution under Article 39, 41, and 43. For that, you have various acts. The Employee State Insurance Act 1948, Employee State Insurance Scheme, which provides for cash as well as medical benefit, which is in kind, and Employees Provident Fund and Miscellaneous Provisions Act 1952, Maternity Benefit Act 1961. All these are social security measures. Okay. And you also have the Payment of Gratuity Act 1972, Apprentice Act 1961. All these will give monetary assistance, and acts like Apprentice Act will give uh, a way to improve skills so that people can develop their living circumstances. And there's also an act called the Employment Exchange Act 1969, by which it is mandatory for the employers to notify any vacancies occurring in their establishments to employment exchanges. Similarly, there's an act called Voluntary Workers Education Scheme, which was launched in our country in 1958.